May it please the court. I'm Jeff Fulford. I represent Myra and Ron Brooks. The underlying action was a medical malpractice action, and in the initial brief I went into detail with regard to the medicine and the facts of the case. But in honesty, the real crux of the issue before the court today is the applicability of a pre-treatment or pre-incident exculpatory clause that the appellee, the doctor, had his patient signed before he treated them. Myra went in for spine surgery. Ms. Brooks came out with a nephrectomy, meaning she lost her kidney, as well as a brachial plexus injury. And of course, the claim was of medical malpractice and negligence. At the underlying tribunal, the case was worked up and went through multiple depositions, discovery, and we were coming up for trial. And at the last moment, Dr. Paul's counsel filed a motion for summary judgment based on the exculpatory pre-treatment release that he claims was effective to bar the case. And the arguments that were presented to the trial judge swayed the trial court and he granted summary judgment. So we're here today on an order, and the appellants here, the Brooks, are asking this court to reverse that summary judgment and send it back to the trial court so we can go to trial, so that the Brooks can have their day in court.
Let me ask this question because,
yes,
as I understand it, both the disclosure about not having any medical malpractice insurance and the exculpatory paragraph or whatever appears to have the signature of Ms. Brooks. But on the date line for both of them, and even for the witness, it's got 12/10, which I assume would represent December of 2010, but no day of the month. And I've not really quite seen that kind of a situation before. It happened 3 times on the document. Is there anything in the record that explains that peculiarity?
No, the record reflects that when Myra Brooks was asked on deposition, did you sign this? She said, that is my signature, but I don't recall signing it. So she has no recollection of the dates itself other than that is my signature. And that was one of the issues we raised below, is that it was put undated.
The handwriting on the 12/10, did she say that was also her handwriting?
No, that was never asked, and so that's not in the record either way.
So there's no explanation about why a day of the month is not in those date lines?
Not at all.
Okay.
So that's not in the record. And that was one of the arguments that we raised below, as well as when you look at the form itself, it's the financial disclosure requirement by the statutes for doctors when they don't carry medical malpractice insurance. They have to get the patients to sign these.
Right.
Then underneath it, which was also one of the big arguments we raised with the lower tribunal, look at the font. And I think even in the initial brief, I went around the rules with regard to Times Roman numeral font to show that this font was smaller than the other, and it's very difficult to read.
It is all on the same page, and there's nothing in between, so to speak. And the decedent did sign twice. I mean, she signed both on the paragraph that deals with there's no medical malpractice insurance, and she signed on the one saying, I agree not to sue you. So, I mean, I'm not sure I'm overly persuaded by the argument that there was some attempt to bury that language in the document.
Well, I don't think that there was any evidence in the record below that that was the intent, but I think if you look at this from a reasonable perspective, a patient looking at these documents are going to read the higher, bigger font that I don't carry medical malpractice insurance, because that's what the statute requires the doctor to say, and it even talks about the financial responsibility in the second paragraph. So I don't think, that's not really the crux of our argument here today. The crux of our argument is that this particular attempt to exculpate this doctor in this pre-treatment release was ambiguous. When a reasonable person reads this, they're going to see that the doctor agreed to adhere to community medical standards. And as a result of that, they're going to be thinking, okay, well, this doctor has agreed that he's going to basically treat me the way that the law requires him to treat me, and I won't sue him if he does that. That's the way a reasonable person, I think, would read this.
Let me ask, your opponent seems to suggest that you are putting most of your eggs in the pre-Stanislaw basket, and that if you, your opponent suggests if you just look at Stanislaw, as it now exists, that you lose, is what their argument is.
And that's wrong. We never did that at any time, not before the lower tribunal, not in our initial brief, not in our reply brief. We always acknowledged, because I was aware of Stanislaw, when this case first came up with the lower tribunal, they had a motion to dismiss the complaint based on this release, and that was pre the Supreme Court Stanislaw decision. And the trial court basically denied their motion to dismiss, which of course is different than a motion for summary judgment. But then after Stanislaw came about and the Supreme Court said, we're going to go with and follow the 5th DCA and go against the other 4 DCAs on this bright line ruling, then basically that was the sole aspect of Stanislaw, is that they did away with the bright line ruling. They didn't do away with all of the law that we've had for years and years and years, saying that if you're going to have an exculpatory pre-incident or pre-treatment release, it has to be clear and ambiguous. The people signing it need to know that they're relinquishing their rights in that particular matter. And if there's a provision in that release that basically is ambiguous, such as the Murphy case, the Goines case, the Plancher, the UCF case, all of those are very similar to this one, because it said the defendant in those cases said, we will adhere to good standards, we will do our best to take care of you, we will follow policies and procedures, and that conflicted with the release itself, where the party was trying to basically do away with their obligation to provide due care. And that's what Stanislaw says, and that's what all the cases say, is that if you're going to adhere to these policies and give them effect, that all the parties must know and fully understand why they're doing it. And if there's a confusing or ambiguous portion of it, then basically it's not to be given effect, and it should not operate as a release for the case. If the court were today to uphold this particular release, it would basically allow the physician to evade his obligations to provide due care to his patients. And of course, that's not what the doctors are supposed to do. And also, it would shift the burden of the risk of loss to the patient, who is really the least equipped to handle and avoid complications and the acts that cause the injury and bear the risk of loss. So that's why we asked this court to fail to give effect to this release and to reverse the trial court.
May it please the court, Bill Vigover here on behalf of Dr. Paul. I would like to direct your Honor's attention to the record page 1214, which is the release in question. And I want to represent this in context of the Stanislaw case, which has been acknowledged as being the controlling authority. The Florida Supreme Court has said, when we're looking at enforcement of releases, the sole issue, is it clear and unambiguous, such that a reasonable person will understand.
Well, let's talk about that. Have you found in your research anywhere in the world where this language has been approved by a court? The court says that it's not ambiguous. I mean, it's a kind of an unusual phrasing. I've never seen anything like it. But have you found a case that takes this language, this precise language, and the way this is worded, and has found or has held that this is, a permissible or unambiguous release?
The answer is no. There's no case that addresses this precise language.
So this would be if we agree with you, this would be the first case anywhere in the world that would do that, and that's my finding as well. You don't think that this is? I mean, don't you think that this release engages in salesmanship to get the person to sign the release, and it's that engaging in the salesmanship or hustle that makes this ambiguous? I mean, if the last sentence weren't in there, you'd have won this case. This is an affirmance. But that last sentence is salesmanship and hustle. So that undercuts that really makes this ambiguous. I don't see how you get around that.
You gave me the question, Your Honor, so I'm going to say things I would not have planned on saying, but to answer your question directly, it absolutely is not any salesmanship or gamesmanship. I know Dr. Paul. I've worked with Dr. Paul. The reason that last sentence is there, I hate the last sentence, but the last sentence is there for a reason. It's not gamesmanship. It's Dr. Paul's commitment that I'm asking you to release liability and not sue me. I'm making you sign a document that says you will not sue me, but I'm not giving up my responsibility to do the best I can.
So isn't there a logical inconsistency there? Because as Judge Gross points out, without the last sentence, it's perfectly clear, if I'm going to agree to treat you, but you have to agree not to sue me. And it's when you put in that last sentence that all unravels, because again, you're, as Judge Gross is pointing out, you're making an affirmative assertion, I'm going to do things in a very professional way that doctors do.
We cut right to the chase. I like that. We didn't spend a lot of time. I had a lot of cases. We've cut right to the chase about this last sentence. So, because I thought a lot about this, if you accept appellant's argument, if that last sentence wasn't there, everybody knows the language of the release under Sandler's law is clear and unambiguous. I will not sue you or your group for any reason. And the trial judge said, that's unambiguous. If releases can be enforced for being unambiguous, that's as clear as it gets. So if you're going to make this one not enforceable, because this doctor says, even though we've done this, and you've agreed not to sue me, I'm promising you I'm going to do my best, that's the one we're going to undo? If you'd just taken that sentence off?
When I promise to do my best, I'm also promising I'm not going to be negligent.
No, it doesn't say that. You're adding language to it. It absolutely does not say that. It's saying, you will not sue me for any reason, and all the signer, this is what the signer is saying, Ms. Brooks says, the reason I'm doing this is because the doctor told me, even though I'm agreeing not to sue him for any reason, he's told me he's going to do his best. Do we want really to protect doctors who won't say they're going to do their best and not protect Dr. Paul, who says, I've told my client, I've committed contractually, I'm going to do my best. That's why we're going to undo it. Honestly, think about that if you write this opinion. You're going to undo this release because this doctor has a candid conversation with patients. I've met him. He's the most heartfelt you could ever imagine.
But you're talking about stuff off the record.
Fine. But you can read that from the record. I promise to do my very best.
Let me ask this question, and I guess this is what makes me very uneasy about this. And I think to even cut more to the chase here, we need to focus in on these words. I agree not to sue Dr. Paul. And the reason for doing this is because Dr. Paul will do the very best for me. Assuming
According to community medical standards.
Right. Assuming he didn't do his very best. So all of a sudden, that first level, okay, I promise not to sue you because you are going to do your very best. But here he didn't do his very best. So this collapses because he didn't do his very best. Great guy, wonderful man, loves to put grandchildren on his lap. But guess what? They're arguing he committed medical malpractice in this case and didn't do his very best. So why doesn't the first step, I will not sue you because you've told me you'll do your very best, and if he didn't do his very best, why doesn't that whole thing collapse?
And that's slightly complicated as I've prepared for this argument, but I will say the first part is we're looking at Sandler's law. I think everybody agrees. I will not sue you for any reason is clear. So now the last sentence. The reason I sign this is because I will do my very best.
Well, the reason why I'm not suing you is because.
No, the reason I'm signing this.
It says I agree not to sue. The reason I am doing this, that is agreeing not to sue, is because you're going to do your very best.
Right. He says to the patient, I'm going to do my very best. That's why I agree not to sue. So there's absolutely no question. There's an unambiguous agreement not to sue for any reason. That's clear. Now, if you get into, is this a contractual agreement from Dr. Paul to do his very best? I've thought about that. That's a little complicated. But that's not a medical malpractice case. They've agreed not to sue for any reason in a contract. If they're saying he agreed to do his very best, but he didn't do his very best,
Hasn't he
wouldn't that be a breach of contract claim?
Well, then he's breached the contract and the other side doesn't have to.
Worry about negligence.
If we get that, it's, Judge,
Let's say the case were different. Let's say it were about, let's say he didn't do his let's say the case were about, the fee was charged, but he did fine, there was no malpractice, but he charged too much money and you agreed not to sue. Well, yeah, he probably could rely on this, but, I mean, if he breaches the contract that he made, I mean, assuming, setting aside that it's ambiguous, I mean, why should he extort a promise from a client by making a certain promise and then not living up to it?
well, I'll answer your question, but some of your language, it really strikes me, there's no extortion here.
Well, come on, let's look at what, the client, how many patients are really actively negotiating with their doctor at a point in time when they're ill and looking for treatment?
So let's be very clear about that, Yarna. We cut to the chase, because I don't want you going and conferencing and talking about non-pled issues and non-argued issues. There is no duress. That was a non-pled issue. This was not an evidentiary hearing. There's nothing about this. This was a voluntary, non-emergency procedure. This
We get
patient
that.
could have
We
gone to any neurosurgeon. It's very important to me, because I was worried that we might get off track on that. That's a non-issue.
We understand that.
Okay. So it was not extortion. It was the doctor being candid and upfront saying, I don't have insurance and you agree not to sue me. But I want to get back to the point of what you were saying. The track you're taking, if this is a breach of contract argument saying, I agreed not to sue you because you said you would do your best, and I'm now saying you didn't do your best, that's the issue. That's a breach of contract claim. What got summary judgmented out here was the medical malpractice claim. That was what this release released. If your honors want to write an opinion that says based on this release, because of that last sentence, there's a potential breach of contract claim here, that's your prerogative. I don't have an argument against that. That's a contract. My doctor agreed to do his best. I can't argue that there couldn't be, he can't pre-release a breach of contract in the same contract. But that's what the case would be. And I think that's an important distinction.
I just, and I know we're parsing words here, sort of like in the previous case, but it's so important here, because he didn't, and I know you may say, come on, Judge Sickman, you're really just being, you're too far down in the weeds, but he did not promise to do his very best. He said he would do he said, I realize that Dr. Monsef will do the very best to take care of me. Not do their best, but do the very best. And the allegation here is they didn't.
Well, let's look at the language. I don't know if you have the document right in front of you.
Yes, sir.
But what the signer, Ms. Brooks, signed was that the reason she was doing it is because she realizes that Dr. Paul and his staff will do the very best. It doesn't say anything about what he promised or what he said.
Right.
It's based on her realization. So if this is...
But I thought you said a few moments ago that the reason that's in there is because he makes that promise to his patients. I mean, does he or doesn't he?
Look, I don't have record evidence. I can't give you a page cite of Dr. Paul told...
Even if it's the case that he didn't make a promise and it's just an assumption on her part, I think it still goes back to a point Judge Sickman made a few moments ago, and that is, I agree not to sue you because my premise is you're going to do your best. Well, it seems like the counterpart to that is if you don't do your best, then I am going to sue you.
So I know I'm out of time, but this is reaching into the three primary cases the other side relies on, where there was an equivocation in the agreement. Where it says...
Well, maybe he wasn't equivocal, but maybe she was equivocal when she signed it.
But she's not. That's the whole point, Your Honor. I mean, look, when I read the three cases, look at the three other cases, the Murphy, the JFK, the three cases, the three cases they primarily rely on. All of those are where it says, we're going to meet all the standards, but even when we meet the standards, there could be an injury, so you release us for the injury, meaning if we don't meet the standards, you can sue. This is not that case. This stands totally different. The language is up front first and clearly says, I will not sue you for any reason. All the last sentence adds is, why am I doing that? Because she believes, based on what the doctor told her, that he's going to do his best to meet community standards. It doesn't say, if you don't meet community standards, I'm going to sue you. It's absolutely unequivocal. I will not sue you for any reason because I'm taking you at your word that you'll treat me with community standards. Now, if you're going to find wiggle room in that, I come back to what I responded to Judge Gross about was, that's not going to be a medical malpractice case. That's going to be, did our doctor breach this contract? If you're going to hold him to this language that he contracted to do his best to meet community standards, that's a totally different case.
And how would that case look?
That case would look like you're going to put the patient up, you're going to put Dr. Paul up, you're going to discuss what was discussed, and then you're going to have to reach the issue of, first of all, what is the allegation about not meeting community standards? And then you're probably going to have to go into experts.
What would be the damages for that breach of contract case? That's not a malpractice case, it's a breach of contract case. What would be the damages under that breach of contract case?
You're calling me a little out of turn, but I would say the result would be, if you determine that the contract is not enforceable, then the release not to sue for any reason is gone, and the plaintiff can pursue the medical malpractice case.
Oh, I got you, okay. That's a good answer. All right, thanks. Thank you.
If you please, Court, just a couple of brief comments. Judge Sickland, if I could clarify something, there's no evidence in the record whatsoever that Dr. Paul plays with his grandkids in his lap.
I was trying
No,
to
I understand.
say, good man, but of course, a lot of good men and good women get sued for making
I understand
mistakes.
that. I was
You
making
know.
a joke.
I know.
There are 2 points really that I would like to address following the reply by opposing counsel. Number one is, when we were in front of the lower tribunal on the motion for summary judgment, the lower tribunal focused on the words alone, I will not sue you for any reason. And he totally disregarded the last sentence. And that was the focus of my argument below. But Judge, that's the ambiguous portion that makes the whole clause ambiguous, because reasonable people are going to look at that and think, I will agree not to sue you if you meet community medical standards, or if you're not negligent. That's what negligence is, a failure to adhere to community medical standards. So that was the major part. The other issue is with regard to this contract issue. That's really a red herring, because that's not what we're here on. We're here on a medical negligence case dealing with, is this exculpatory language sufficient, clear, and unambiguous such that a reasonable person would know they've relinquished their rights not to sue the doctor for negligence. And it didn't. Clearly, it isn't, because of the language that this doctor chose to include in it. Breach of contract, by the way, a breach of contract doesn't have the damages that opposing counsel says. Breach of contract has been long recognized as a theory of suing a doctor for medical negligence. You can look at 3 or 4 different statutes that are still in effect that talk about, if you sue the doctor for injuries because of his care, you can do it under breach of contract or negligence. But for the most part, people don't choose breach of contract, they choose the negligence issue. Thank you.
Thank you.